Hi, I'm Kevin Kneupper. I'm an attorney with Kneupper and Covey, and I want to talk to y'all today about a big lawsuit going on between two YouTubers, both of whom are sort of involved in the influencer boxing circuit. And the lawsuit stems out of a big boxing event that was called the Battle of the Platforms, and it was run allegedly by or set up by Austin McBroom. The lawsuit is over a failure to pay Jarvis, who is one of the people who boxed in that event. And Austin McBroom and his dad are about to lose this lawsuit by default and have to pay Jarvis $1 million. And that could be really bad and really dramatic, I guess, because when you lose a lawsuit by default, when someone gets a judgment, they can just start taking your stuff. So you may, in the near future, see Jarvis grabbing cars out of Austin McBroom's parking lot, grabbing his house, taking anything he owns until he gets that $1 million paid. Unless something changes, unless Austin McBroom figures it out and gets some lawyers in there, he is about to lose this lawsuit by a TKO in boxing terms and be done. So what's happened? How did we get here? What's been going on? This is a lawsuit that was filed pretty recently in state court in California. And it was filed by Jarvis. He sued Austin McBroom. He sued Austin McBroom's dad, Allen McBroom. He sued a number of, or a company that was allegedly run kind of in secret by Austin McBroom as part of this boxing event, the Battle of the Platforms. The Battle of the Platforms was supposed to be a big kind of thing that was going to be put together where these people from YouTube would go box people from TikTok, and then they would be pay-per-view. They were hoping to get a bunch of subscribers for it. It kind of was a bust, and there's a lot of lawsuits that have happened out of this, or a lot of disputes anyway, and people are saying they didn't get paid. Jarvis says that he had a contract that would pay him $1 million to be in the fight if he went in and did it, and that he never got paid sort of the fight amount. He says that there was a lot of hype around this, that Austin McBroom organized it without telling anyone that he was behind it, and has attached to his lawsuit a bunch of documents that I'm going to go through with you in a bit that are sort of pitches for this, that what Austin McBroom was supposedly saying to investors. And they kind of give us a lot of insight into how one of these events gets put together, but also how one of them can go very, very wrong and lead to lawsuits like this. What has happened since then is that Austin McBroom was supposedly served via what's called substituted service, which means he was not actually handed personally a copy of the lawsuit, but someone at his house who resides there with him was given a copy of it. I'll go through that. It's not really clear who that was. They just call it a Jane Doe, which means that the process server walked up and just saw a woman and handed it to her. So will this hold up or not? I don't know. But what's happening right now is that Jarvis has asked the court to enter a default judgment. A default judgment is just kind of like a TKO in boxing, or someone doesn't show up or whatever. If you don't show up to your lawsuit, the judge can just make you lose. And if that happens, what Jarvis is in the process of doing is asking for more than $1 million to be awarded to him by default, with no way for Austin McBroom to answer that. Now, Austin McBroom and his dad, and they can come in and answer this still right now, even though that they failed to answer the lawsuit. They could hire a lawyer and go do something about it right now. But if they don't do something, in the near future, they could have this default entered against them, and there will be a clock ticking for them to actually do something about this to try to get rid of it. If they don't, then literally Jarvis will have a judgment against them, and you may see some YouTube content where Jarvis and his lawyers are showing up just taking stuff from Austin, because that's when you get a judgment, you can go do that. You can go take any property that person has, subject to certain limits, but a Lambo in your driveway is not going to stay in your driveway if you own it. They can go just take things. They can take your bank accounts. They can take whatever they want. And a lot of times when people get one of these, they try to do it they try to take things in the most painful way possible, to encourage you to go pay for stuff. So if one of the things that could legally be taken is the McBroom's right to YouTube content, to their name, something trademarked. There's all those things can potentially be taken with a judgment, and so they need to do something about it. Is the short version of this. But I'm going to walk you through what was filed in the lawsuit. If you are friends with Austin McBroom or fans of him, you might want to go tell him, hey, take a look at what's going on in this court. And I'm going to go show you the complaint, and there's a lot of very interesting things that are alleged there, and I'm going to go through them in detail as a lawyer often does. And I'm also new to YouTube, so I forgot the mandatory pitch at the beginning of the video, or the early part of the video, for y'all to subscribe if you want to hear or see more videos like this. I've only done a couple so far, but I will be making more, talking about all these random celebrity lawsuits that I'm finding. I found this one just digging around in the court dockets, so you may not have seen it anywhere else. I really haven't seen anyone else talk about this. And, you know, hopefully I don't get too YouTubed out. If you ever see me with a thumbnail with my mouth wide open beyond human possibility, then you know I've gone way too far into the YouTube world. For now, I'll just do it, you know, like an amateur. So. Okay, so before I get into the details of the complaint, I want to talk about what happened more recently, which is this request to enter default, just because that's a little more quick and you can kind of see it real without getting into too much. So this is a document that was filed in state court in California in this lawsuit, requesting an entry of default. You can kind of see they say they're requesting an entry of default against Austin McBroom and against this company. And they, you can kind of see the amounts here. So the amounts of this default that they're asking for is $1,166,709.75. That is if this lawsuit is not answered, if Austin McBroom doesn't jump in and do something about it, then the court will enter a default judgment against him for that amount. Now, I will say, as a lawyer, there are ways around that, even if this goes ahead and happens. There are sort of two ways that you can deal with it with two deadlines. One is within 6 months. If you can show that there was excusable neglect for this, then and that can't just be, oh, I'm messing around. You know, it's got to be some very good reason for why you didn't come and answer. Then you can overturn the default judgment even if it gets entered. The second way that Austin McBroom could deal with this is within 2 years, he could come in and if he shows that he did not have actual notice of the lawsuit, then he can overturn the default judgment that way. That means he had to not actually realize that this lawsuit existed. If he does know about it, or he can't prove that he didn't know, because it'll be on him to show that, then the court will leave it in place, and he'll just have to pay this with no way to really defend against it. I will say, courts do have a preference for not having lawsuits decided by a default, by a TKO. They want you to go have the fight, see who would actually win. I've actually gotten one of these overturned in a different case more than 5 years after the lawsuit got filed. That was a very special case, though, with a certain type of law, and so that only applied to that type of lawsuit. With this one, it really is something that Austin McBroom needs to get on, or he's going to have this very big debt that he's going to owe to Jarvis. Okay, and what I'm showing you now is something that's interesting, which is what's called a proof of service. And so this, at least for Austin McBroom, is something that if I were representing him, I would be looking at this pretty closely. This happens in every lawsuit. Basically, you have to do what's called service of process. And so people have a right to be notified of a lawsuit. And generally, the way that you are supposed to do that is literally go hand them a copy. You probably see that in television. There's TV shows where someone will walk up to someone and go, "You've been served," and hand them. They kind of might act on TV. They act mysterious and pretend to be a pizza delivery person or something, and then pop out with an envelope. You're not actually allowed to go lie to the person. But you can't just sort of drop the lawsuit in front of them if they refuse to take it. And that's the way that you're supposed to try to do this. Now, you can see here. The box in the form for personal service is not checked, which means Austin McBroom has not actually been handed a copy of this lawsuit. What was checked instead is by substituted service, which says that December 12th, 2022, the process server came up to Austin McBroom's house and handed a copy of the lawsuit to a Jane Doe, a woman who wouldn't tell the process server her name, who the process server says was a co-occupant, who is age 25 to 35, weight 130, 6 foot tall, race unknown. You can see that also the box is checked that this is this person who's the Jane Doe was a competent member of the household, at least 18 years of age, at the dwelling house or usual place or abode of the party. I'm informed of the general nature of the papers. Now, that's one thing that is a little. Let me, I guess, talk about what substituted service is first. And you can see, if we go scroll down here a little more, the they do what's called, you can see there's 3 service attempts. So before this happened, the process server says he tried twice. He went to this gated home. He tried the doorbell. There were no lights on. He tried again the next day on December 10th. No answer to the doorbell. Nobody there. There was a red Tesla in the driveway. And then 2 days later, on December 12th, he says he went and served this woman who's a Jane Doe, who exited the home and entered this red Tesla that he'd seen in the driveway before. Now, one potential problem for Jarvis is that it's not really clear from this declaration. How does he know that this person is actually a co-occupant? It may be something that you can imply from her having access to the red Tesla in the driveway, but it could also just be someone who is staying there for a few days or something. That could create a legal issue for whether this service is actually proper. Is this Jane Doe actually someone who lives there? Given that and actually it looks here like he says it's a pretty big range for the height. The height is 5'6" to 6 foot tall, which it makes you kind of wonder, how do you, it seems like with a woman you would be able to know at least a little closer than 5'6" to 6 foot tall, how tall they were. And then above it says that she was, he says her height was 6 foot. So there are some sort of potential issues there that if you're Austin McBroom, it's a little bit, how did you not know whether this woman was 5'6" versus whether she was 6 foot tall, and how do you actually know that she's someone who is living here versus just some person who, has been here a couple days or was a friend hanging out, or maybe not even Austin's friend, but just someone else at the sort of Ace family abode who's just hanging around there. So there are legal issues that whether you could challenge, did Austin McBroom ever get a copy of this? What did the Jane Doe do with this lawsuit? Now, the longer this goes on, the more it's kind of like, hey, this is a thing out in public, and it becomes harder to believe the longer he waits that he would have no idea that this is going on. But just given how high profile he is, and I'm literally making a YouTube video about this, so the more that it gets talked about, and the more it sort of gets out there and people know about it, the more that he would kind of have to say, hey, at some point, when he knows, he's got to go in and do something. But so that's what allegedly happened with the service, and that has ticked off to this sort of countdown to a automatic default judgment against Austin McBroom. Now I'm going to go show you the complaint and what was alleged, and some very interesting things in there about how these celebrity or these influencer boxing events are actually organized, about some of the hype that was in there that Jarvis says was totally false, and some of the things Jarvis says that Austin McBroom, through a shell company, was promising to people who were going to be participants in this Battle of the Platforms pay-per-view event. Okay, here is the complaint in the lawsuit between Jarvis. You can see he's got his real name there, along with Simply Greatness Productions, which is a Delaware company, Austin McBroom and his dad, Allen McBroom, and Doe's 1 to 50. Now, how some of this works is this. Doe's 1 to 50 is just something that gets included there a lot of times. That just means a John Doe who may be involved, who I don't know. Those have actually now been dismissed from this case, so that kind of just means nothing. Simply Greatness Productions LLC is a company that, when you start going through this lawsuit, the lawsuit alleges that company was the one that ran the Battle of the Platforms and organized it, but that it was actually being orchestrated by Austin McBroom, who was the top card in the boxing matches. So basically, the allegations are that Austin McBroom was kind of using this to basically self-promote. So he got a bunch of other influencers involved, was telling them, hey, come be part of this fight. But that the whole idea was just to go put him at the top, make him be the main event, and then kind of promote himself and his own career. And Jarvis alleges that a lot of these people would not even have been involved if they'd known that Austin McBroom was the one sort of running and profiting from it. So this has some allegations here that I won't get into too much because they're sort of, stuff about Austin McBroom doing other things that that we don't need to get into here. But Jarvis also alleges that Austin McBroom basically had set up this thing with some people that he got to promote the fight, where they would transfer the ownership of the LLC around, and then it would sort of return to him at the end. And it's devious plotting is what it calls it up here at the top. And then that they were going around to investors. And I'm going to show you in a minute these Exhibit 1, Exhibit 2, which are, this says, are marketing decks or pitch decks to investors. It says that they showed Kevin Hart, who's a comedian, was going to be the host, but that he actually was never going to be the host. He was out of the country, and that they were kind of using crazy math to pitch this boxing event to potential investors in it, and those included James Harden and Lil Baby. And Lil Baby is someone who actually performed at the event. And this says that Harden and Lil Baby advanced $2 million total to basically start running this boxing event. It's kind of how when you have an idea for a business like this, something that happens, and so the idea of having a pitch deck is not unusual. It's usually the person who has the idea or who wants to run it may not have the money to do this. They may not have enough to invest. $2 million may not have been the total amount that was even spent on it, but just sort of a startup amount. And what you'll do is you'll go around to different investors with these pitch decks, which are just PowerPoint presentations or slides or whatever that sort of try to tell the potential investor, hey, here's the kind of money that you can make. Here's what you might be able to make if you invest in this. Here's why, give me that money and I'm going to go make this business or this, in this case, a sort of business opportunity work out for you, and we'll all make a bunch of money. So we'll look at those decks later, but the lawsuit's alleging that they promised sort of unrealistic amounts, that they would basically make $500 million in pay-per-view money, and that for the gross revenue, which is not the profits, but is the amount that they were saying they might take in. And this says that this company that was allegedly being run by Austin McBroom was promising people up to $5 million to come fight in this battle of platforms. It says that he offered $1 million and $25,000 to Jarvis, and that Jarvis was given the $25,000 up front, but that the rest of it was contingent on him actually fighting in the event, which that's sort of something that you would be common in a contract like this, because you want to make sure the person actually shows up. You don't pay them and then they just sort of get drunk the night before and don't show up. Or at boxing, sometimes you'll see boxers weigh in and they've just not trained and they are not really in fighting shape or even able to do anything. And so there are usually provisions like that. But what Jarvis is saying is that he did fight, he was there, he was ready, the event happened, and he never got paid his money. This goes through a little more. It says that there was kind of a spending spree. This is quoting what are supposed to be text messages or emails between them, that there's between the people who are organizing this with Austin and Allen McBroom, saying they're spending like drunken sailors. It says they sort of worked with a live stream partner, that Austin McBroom wasn't listening to what they were doing or what they were telling him to do. They were warning him that he wasn't going to get more than 200,000 pay-per-view sales, which would not equal $500 million. It'd be a lot of money, but not that much money, and maybe not even enough. If you're at $50 a pop, you might be getting 10 million tops, even if, and I don't know if this even was a $50 type pay-per-view. But this also says, this was kind of an interesting alleged text message. Don't know if it's real or not, but Jarvis says that this is a text message that was sent to Allen McBroom, or to the McBrooms, but that Allen McBroom responded to. That one of these organizers said, "Hey bro, you left us a voicemail over the weekend on how concerned you are with us not communicating, and that we're making deals with artists and promising all this money that we don't have, and that we're pulling a Ponzi scheme." If that's a real text message, that obviously would be kind of a smoking gun type thing if it exists. I can't tell you whether or not it does, but that's what Jarvis is saying. Somehow he has proof of this. He says that the actual audience was only 136,000 people, which is way less than what Austin McBroom was telling people it would be, or his promoters were telling people it would be, and that then there just starts to be a bunch of deflecting and people trying to shift the blame around, and everyone's kind of wondering why it went wrong, and then Jarvis says he just doesn't get paid. And you can see him kind of start talking about just his general background, all this. Then there's a lot of more legal stuff that's not really as interesting, because it kind of just different things that you have to say to try to meet legal requirements to do all these different parts of the lawsuit. Complaints are the first document in a lawsuit, and so they will lay out all these different what are called causes of actions. And so you can see, we just look at a few of these. Fraud is one of them. So their causes of actions are just legal ways that you can sue people, or theories you can sue people under that would get you money back. So he also has breach of contract. That just means you breached a contract. And so if you breach a contract and certain requirements are met, then you got to pay the person money that you owed under the contract. This one's negligent misrepresentation. It's kind of a lesser version of fraud. So fraud's when you are just intentionally lying to somebody. Negligent misrepresentation is when you tell someone something that isn't true, but it wasn't that you didn't know necessarily that it wasn't true. You just sort of you weren't careful about whether it was true. And Jarvis doesn't have to prove all of these. He can prove one or the other. So he can plead things that are inconsistent. Like, for example, fraud is inconsistent with negligent misrepresentation, because if you know, then you obviously committed a fraud. If you for negligent misrepresentation, you have to have just been negligent. But the reason plaintiffs are allowed to do this in lawsuits is because sometimes you don't know, and really anytime you're filing, you don't really know the truth of all the facts that are in the possession of the other party, the defendants, right? So Jarvis doesn't have all their emails, their text messages, and so you plead both of these, because if it turns out, hey, Austin McBroom didn't actually know, but he was just sort of not paying attention or doing something, that like he basically he just was negligent. He didn't really be careful about it. Then you still would win your lawsuit. So you plead all the potential ways that person could be liable, depending on what the facts are eventually proven to be, as long as you have kind of a good faith basis to think that it might be one of those. So Jarvis filed this lawsuit. He asked for $1 million. Now he's asking for default. The really interesting part of this, I think, is these exhibits that he attached, because we get to see some actual documents that were being allegedly given out to the potential investors, Lil Baby and other people, about what this would be like. And you can see these are so this document is supposed to be handed out before this actually happens. The names of some of the people involved may not be the actual ones who were there, or who. But what happens in something like this, it's similar to what happens in movies. So you get people who will kind of commit to do it. If this happens, they say, I will. You can use my name. You can pitch that I'll be there. If you manage to put it together, I'll be one of the boxers in this. And so these people were ones who were kind of, if he talked to him, and I don't know, sort of what actually happened here, but normally you would have these people kind of signed on provisionally to do this, not actual contracts, but just, look, I'm committed. You can see that this does have the numbers that Jarvis is saying that it had. It's talking about all these different follower counts, the total followers that they have on TikTok and YouTube, the projected number of people who would stream this, which is $10 million. He's assuming 2.5% of the followers would purchase, which is, that's where Jarvis is saying that's pretty unrealistic. And then it projects that they will make $500 million based on a pay-per-view average ticket price of $50, $49.99. That did not happen. This is what's alleged in the suit, and that it was a much, much smaller number, less than 200,000 people, and that this basically was a total dud. You can see another pitch deck here, which is also another thing that was allegedly given to the investors. You can see it again. It's talking about total reach of these people that are sort of signed on to be associated with it, between YouTube, TikTok, Instagram, being 702 million. Estimating 5 million pay-per-view purchases, and this one estimates the gross revenue with a ticket price of $40 instead, and 200 million. And it says Kevin Hart will be the host, James Charles will sing the national anthem, and they'll sell the tickets at a range from $29.99 to $49.99, depending on when you buy it. Part of what Jarvis is saying is that basically these numbers for TikTok, YouTube, Instagram are not realistic in terms of what an actual purchase would be. That, I think anyone who has followed influencers over the last several years knows that sometimes people, some of the followers may be bots, some of the followers may just not be really paying attention to the person anymore. When you talk about total reach, that doesn't necessarily mean that the people actually see what you post, or that they buy because you post about it. Especially, this is something, there's a generational gap, I guess, between, if you're younger, you probably know exactly how all these platforms work. If you're older, and generally the people you pitch investments to are much older, they're maybe in my generation and not the younger generation. People in my generation or older than that, so 40s and older, may not really know how these platforms work. I actually only started using TikTok a couple months ago. I didn't realize that a view on TikTok could be like a little less than a second swipe on it. And so if you could be telling some older investor, hey, I have, 1 million views on this TikTok video, and they may not realize that of those people, the people who watched past 2 seconds might have been a fraction of that. And so Jarvis is kind of saying this whole thing was just, hype. And that part of the hype was telling the people who were actually going to get up and have to box that they were going to get paid these $1 million to $5 million, and Jarvis says he wasn't actually paid this. You can see Jarvis attaches some of the posts that were being made here. I think these are actual posts that were done as part of promotion. But the other thing that's interesting that he attaches is this contract, and you don't usually get to see what these actually look like. You can see that at the time Jarvis was part of this Faze clan. Faze clan, if you don't know, is a like a gaming group that gets together a bunch of gamers who compete in esports, and they all kind of co-promote under the same brand name. So at the time he was calling himself Faze Jarvis. Now he's just Jarvis. And this contract was actually between this Faze Clan Inc. and Simply Greatness Productions. So it was basically a contract between this company that was supposedly owned by Austin McBroom and this company that is sort of, it looks like the overall company behind Faze Clan. What that would mean is that it looks like Jarvis was using Faze Clan kind of like a manager, where the manager might negotiate contracts on his behalf or have the right to go sign him up to do things like this with his approval or whatever. We don't know that part of the deal, but we know that that's why you see stuff here saying, protecting the trademark for Faze Clan, and why Faze Clan is sort of all over this contract. And Faze shall cause talent, which is Jarvis, to commit the services, which is the boxing. They specified the competitor is going to be Michael Lay, which I believe is actually the person who he did fight. And they put all these details in, like how long are the rounds going to be. If Michael Lay backs out, well, we have to have a replacement who's the same size, same stature, same level of experience. You can't bring in Mike Tyson to go beat me up, or somebody like that, whoever the current champion is. And then they set out all the details of, and if you ever become an influencer, this is what the contracts will look like and what they'll say. They'll have all the details of what you're going to do, how many posts you're going to make, exactly how much money you're going to make, when they're going to make it. But this does say in this contract that this this company is going to pay Faze Clan, or I guess Jarvis through Faze Clan, $1 million if the fight happens, and sort of has timing for when that's going to happen. Here's all these kind of promotion things. They're going to do a photo shoot. They give this company the right to use Faze Clan, Faze Jarvis, but only in connection with the event. They got to have insurance. It's all details. If people who are influencers or want to be influencers should actually learn how to read these kind of contracts. You should learn the details of these kind of contracts, because people can get in a lot of trouble. And I've made some videos on TikTok and other places about what happens if you sign one that has real bad things in it. For example, some people have signed power of attorney to their managers, which is just a disaster. You ever hear that phrase? Do not sign the contract. Do not sign a contract with a power of attorney. It's a little aside, but this is one of the contracts. This one is sort of just a standard one. Nothing too crazy in here, but it does show kind of all the things they negotiate and how this got negotiated. This part is interesting, which or would be if Austin McBroom and his dad show up, is that they had a right under the contract to compel, or this really under the contract would not have been a lawsuit. So it has what's called an arbitration clause. And arbitration versus a lawsuit is you're supposed to do it in private. You do it before, this says JAMS. JAMS is a group of former judges mostly, and there's some law professors and things like that in there too, but basically very qualified lawyers who act as what's called an arbitrator. An arbitrator is just kind of a judge who does things in private without a trial. You do a hearing. They're usually on Zoom now. There's like a streamlined version of kind of the evidence collection stuff where you have to trade documents, and you might have to do a witness deposition, but it's nowhere near as long or as expensive as doing a full-on lawsuit. Now, Jarvis did not really do anything wrong by filing in court. He's actually allowed to, under California law, and I've been in this situation too, where you can go file in court to sort of test whether that agreement's going to hold up. This is a pretty short clause. If this, there's a lot of different ways an arbitration clause can be invalidated, but in recent years, the Supreme Court has made it very hard to do that. And it's especially hard when you have two sort of very sophisticated parties negotiating contract. Here, Faze Clan is a group that basically does this all day long, negotiating these contracts. It's going to be hard to say that they just didn't know what's going on. Same thing with Austin McBroom. He has, managers behind this. And so, it's a lot harder to challenge a clause like this whenever both parties are kind of sophisticated versus if it's, say, just some random person signing this. they might have a better reason to say, hey, I didn't know what that was. But even then, these things are difficult to stop now because of just sort of a whole legal trend in favor of arbitration. So the short version of that is that Austin McBroom would have a good shot at compelling this case into arbitration. He would have to go before the judge and say, hey, one, he'd have to say, hey, I'm actually here. Sorry for not realizing there was a lawsuit, but also I want to compel this lawsuit to arbitration, and then it would be done in private. It's a little, the cat's kind of already out of the bag in terms of some of these details, but there's really nothing that can be done about that at this point. And there's no really way to contest that because that's just what the law is. And so this has just sort of these various different provisions. It's got signatures. You can see the signatures. Not Jarvis, or there's Jarvis actually signing as the talent. There's someone signing for Faze Clan, and then there's this person who is the Paul Sazers, who's I guess alleged to be one of the organizers, who is working with Austin McBroom. We go down here, and you may be wondering, well, if the contract's with Faze Clan, then how's Jarvis filing a lawsuit? Well, this next exhibit addresses that, which is it's something called an assignment. And so at some point, Jarvis leaves Faze Clan. They got to kind of, it's a breakup, right? So whether it was a good breakup or a bad breakup or whatever, I don't know if there's bad blood or however they feel about each other, but Jarvis went his own way. He's off to greener pastures doing his own thing. And you have to sort of figure out what do you do about all these contracts that Faze Clan had been signing. However, whatever deal they worked out, Faze Clan assigned the rights under this agreement to Jarvis. So now what used to be a contract with Faze Clan, Jarvis has now become kind of the owner of the right to sue Austin McBroom, Allen McBroom, any of these other people. He's now the one with the right to that $1 million instead of Faze Clan. And so that's kind of the summary of the lawsuit and where it stands now. We don't really know, will this default judgment get entered? Will it be granted? What's going to happen with that? If Austin McBroom does not show up, then there will be a default, and it gets harder the longer it goes on to try to undo that. He may have some arguments here because of sort of this not being him who was served personally, but them trying to serve him personally and then failing, and then serving the mystery woman who may be 6 feet, maybe 5'6" or whatever. Process servers do some strange things sometimes. I've seen some bad things done by process servers, and who knows what happened here. But Austin McBroom definitely wants to show up and defend, and Jarvis definitely, he'd be happy, I'm sure, winning by default by the TKO, and he's put all this stuff there. If Austin McBroom does show up, then they would likely go to arbitration to fight it. If they don't, then they keep fighting in court. There's advantages and disadvantages to both. At this point, Austin McBroom is sort of a public thing, so he may want to actually get his say out into the public arena so people know what his side of this is. But we'll see, and we'll be watching it, and I'll keep you all updated on it. If you want to hear more videos like this, more analysis of random celebrity legal fights with one another, or just more legal question videos, I'm going to be doing a bunch of those, answering just sort of questions that people have about consumer issues or the types of lawsuits I do, which is suing people who are kind of getting cheated by big companies or small companies. Hit subscribe, and then you can see all the incredible legal minutia that I get into on these things, and understand kind of what's actually going on in some of these lawsuits where you're just seeing a headline. So